Good afternoon, everyone. Welcome to our webinar entitled Data Privacy, Security, and Innovation, the National Privacy Commission Perspective. This webinar is hosted by the Fintech Philippines Association. Welcome, everyone, and thank you for joining us. Just a few reminders before we start. First of all, we will have a question and answer portion from our, please utilize the question and answer tab below if you have any questions for our guest speakers. Please raise your hand if you'd like to ask questions later on. We will have a moderator call you in. To start our program, may I now call on the Trustee and Executive Director of Fintech Philippines Association, Ms. Amor Maclang. Ms. Amor Maclang, good afternoon.
Good afternoon, everyone. Mabuhay po tayong lahat. I would like to first and foremost thank and welcome everyone. We have a record number of attendees for today, and at 500 plus attendees. Magandang hapon po sa inyong lahat. This is probably one of our most popular webinars and learning initiatives this 2022. Now, as transactions become more digital and even more remote, cybersecurity and identity protection, which has started to become a very important advocacy for us in Fintech Philippines Association, has become even more crucial as we take on this advocacy to tech up the country. What's truly important to understand is that our financial information, our personal information, our history, our transactions, our payments, which are currently being held by third parties and other institutions, we need to recognize the fact that these belong to us. So this is the beginning, not just of our advocacy with the new leadership of the National Privacy Commission, but more importantly, data protection revolution, wherein the owners of the data understand that you cannot just sign your rights away for an umbrella or a chance to win in a raffle. We have full control. We own this particular data, and we are going to step up to take control of our financial activities with, of course, the help. I'm averse to call them a regulator because we really look to them to become an enabler in this space. We need to be able to work closely to understand what this data can do for us and how collectively we need to start working together in a whole of nation and a whole of country approach towards protecting our information and also at the same time protecting overall our country. Last June of 2021, we really hit a blow as the Philippines was included in the gray list of the FATF. And then shortly after, in that same year, last November, two important domestically significant financial institutions were actually caught in a special situation. Let me just leave it at that. And what we want to be able to do is to work closely with not just our regulators, with the NPC, with the BSP, so that we can have a different approach to breaches. It's not just a function of if it will happen, because we know it will happen with the acceleration of payments in the space, but we need to revisit how we all work together, not behind walled gardens, but working together in a spirit of exchange of information and working closely with our enabler regulators. Last but not the least, The reason why we wanted to give the floor to the NPC is because of our continued advocacy, which is to increase the innovation and the technology quotient of the country. Many of the associations and the organizations have actually hidden behind the veil of the NPC to use it as an excuse not to innovate. We've had a very, very different conversation, especially with the new leadership of the NPC. And today, we're going to hear from Commissioner Aguirre, who has very kindly accommodated our request to speak to you today so that we can see how we can work closely together in order to create an innovative environment for the country. Last but not the least, we look forward to supporting the National Privacy Commission to continue to engage and work and listen closely to the needs of the financial services industry via researches, charrettes, and also at the same time focus group discussions, which can lead up and ladder up to a learning summit, hopefully sometime within Q2. So on this note, we really look forward to creating a virtuous cycle within the financial services industry and also with our regulators, so we can continue to transact in confidence and in trust. Maraming salamat po. Mabuhay po ang National Privacy Commission. Mabuhay po ang Fintech Philippines Association. And we look forward to having all of our 500 plus attendees today become co-advocates of the NPC and also members of Fintech Philippines Association. Mabuhay po tayong lahat. Back to you, Chino.
Thank you so much, Ms. Amor. And now it is my pleasure to introduce our guest speaker this afternoon. Our guest speaker is a lawyer, law professor, and privacy advocate. He received his Juris Doctor degree from the University of the Philippines College of Law in 2009 and was admitted to the Philippine Bar in 2010. In 2013, he obtained his Master's of Law from Harvard Law School, where he took subjects on, among others, mergers and acquisitions, information privacy, and corporate and capital markets law and policy. In 2014, he was admitted to the New York State Bar. He has wide experience in expertise in legislation, serving as advisor for both Senator Edgardo J. Angara and Senator Juan Edgardo Angara in the formulation and implementation of the respective legislative agenda, including the bill that eventually became the Data Privacy Act of 2012. Please welcome Deputy Commissioner of the National Privacy Commission, Attorney Leandro Angelo Y. Aguirre.
Hi, good afternoon, everyone. First, I'd like to thank Amor and the Fintech Philippines Association team for organizing this event. And for all of you here this afternoon, I truly appreciate your efforts in recognizing the importance of data privacy and information security in your industry's endeavors. First, I'd like to disclose that I'm not an expert on fintech. So I hope you'll permit me to still share some thoughts from a data privacy perspective on how we can protect the rights of our data subjects and ensure compliance with the law, but do so in a way that does not kill innovation and end up depriving Filipinos of the benefits of digital technologies that have changed how we interact, have changed the way we shop, how we order food, and as we've seen during this pandemic, basically how we now live our lives. Whether this is ultimately for the good or not, I think each and every single one of us here has a role to play in shaping that future. The word Amor used earlier is apt. I hope we can be co-advocates in shaping this for the better. A New York-based creative agency, We Are Social, found that as of Jan 2021, there's a total of 38.88 million Filipinos making digitally enabled payment transactions. These transactions include payments for products and services made over the internet and mobile payments at point of sale using smartphone apps. Aside from this, a recent study by Bain and Company and Facebook found that by 2026, Southeast Asia's digital consumer population is expected to reach around 380 million, 1.4 times bigger than it was in 2019. Taken together, these studies tell us that digital-centric consumption in the Philippines and Southeast Asia is here to stay. In a 2017 survey conducted by the BSP, 46% of account holders who have access to the internet are wary of e-payments due to issues such as hacking and data security. I'm sure if a survey were to be conducted today, the numbers will be much higher. More people will be wary because of a lot of issues that I'm sure you're all aware of, involving the use of digital technology, including those related to certain companies engaged in online lending. The rise and fall of these companies, unfortunately, pose a challenge to the rest of the industry and includes those whose business heavily relies on the processing of personal data. Of course, it goes without saying that it affects not just those who are bad actors, but even those who operate legitimate businesses. All of these made the public more aware of the very real threats brought about by these fast-evolving technologies. Based on the comments and questions we received during last week's symposium on online lending applications, it's easy to conclude, and this is putting it nicely, that the public's trust in this particular sector is not exactly high. A sentiment we consistently see goes something like, bakit pa ba hindi pinapasyara yung mga online lending apps na yan? Wala naman silang mabuting nadudulot. From 2018 to 2021, NPC received a total of 2,110 complaints involving online lending applications. While it's true that not all of these are legitimate complaints, and some complaints are born out of a misappreciation of what is covered by NPC's jurisdiction, what cannot be denied is the importance of the industry and the government working together to gain the public's trust. Gaining or regaining this trust necessitates being able to demonstrate that this entire industry is complying. After all, it only takes a single pasaway company to ruin the image of and discredit this entire industry. The Data Privacy Act of 2012 mandates the National Privacy Commission to protect the fundamental human right of privacy of communication while ensuring the free flow of information to promote innovation and growth. Contrary to what some people might think, these two are not mutually exclusive. As a regulator, the NPC seeks to create a regulatory environment that encourages and incentivizes the accountable use of personal data without stifling innovation. I hope after today, we can start looking at privacy not as a barrier to innovation, but as an enabler, a crucial factor that affects the flourishing of particular sectors. Hopefully, today's discussion will help clarify this. Over the past 5 years, the NPC has advocated the 5 pillars of compliance, which serves as a guide for PICs and PIPs in terms of their obligations under the DPA and the relevant issuances of the National Privacy Commission. By way of review, and I apologize for those that are familiar with this or are tired of hearing this, these 5 pillars include the registration of a data protection officer, the conduct of a privacy impact assessment, the creation of a privacy management program, the implementation of data protection measures, and the regular exercise of breach reporting procedures. If these things are already present in your organization, then I would like to commend you for making data privacy a priority in your business. I'd like to emphasize, however, that compliance with the DPA entails more than just simply ticking off boxes on a checklist. It involves conducting activities in a series of activities within a framework of protecting the data subject from very real risks such as discrimination, stigmatization, social exclusion, to name a few. This means PICs and PIPs. So for those that are not familiar, PIC stands for Personal Information Controller and PIP stands for Personal Information Processor. So this means that PICs and PIPs have to go beyond simply knowing what needs to be done. More importantly, they need to have a deeper understanding of why they do the things that they do. Remember that at the core of the obligation required of companies that process personal information under the law should be the data privacy principles of transparency, legitimate purpose, and proportionality, as well as the preservation and protection of the rights of data subjects. These rights are provided under the DPA. But for purposes of today's discussion, I just want to focus on the data subject's right to be informed, as this also goes hand in hand with the principle of transparency. In an advisory on data subject rights, the NPC stated that data subjects have the right to be informed of the existence of automated decision-making and profiling in the processing of their personal data. In particular, this involves the methods utilized for automated access, if the same is allowed by the data subject, and the extent to which such access is authorized, including meaningful information about the logic involved, as well as the significance and the envisaged consequence of such processing for the data subject. The requirement to use clear and plain language is intended to ensure that data subjects are able to exercise meaningful control over their personal data. Remember, when data subjects don't understand the methods and extent of your processing, what you're doing with their processing and why you're doing it, they definitely won't be able to gauge the impact of these decisions on them. Despite all of these, however, we should realize that it is unrealistic to expect that all data subjects can truly understand all of the information provided to them and properly decide for themselves how to weigh the costs and benefits of these types of processing. As data subjects, and yes, all of us are data subjects, I think we should recognize that our ability to make decisions based on the deluge of information we're faced on a day-to-day basis, and to gauge the impact of each of those decisions is finite. The idea of consent fatigue is a real thing. Given all of these, PICs and those they contract to develop their systems can't pass the entire burden to their data subjects with the expectation that their consent will legitimize all manner of collection, use, and disclosure of personal data. Precisely because the right to privacy is a fundamental human right, meaning it is essential for the enjoyment of all other rights. An obligation of PICs is to ensure that their processing is not only lawful, with a clear and specific purpose proportional, but above all else, that it is fair and just. This means looking at these things from the perspective of protecting their data subjects, especially those who do not have the ability to protect themselves. I want to stress that personal data, even when it is disclosed by the data subject, still belongs to the individual data subject. Everyone else is just a custodian. Keeping in mind the objective of gaining or regaining the trust of data subjects, PIC should handle personal data in ways that their data subjects would reasonably expect, and not use it in ways that have unjustified adverse effects on them. This now leads us to an all-encompassing framework that I believe can help the sector, including those specifically engaged in online lending, ensure that all of the things that we have mentioned are fulfilled. And that is looking at privacy based on trust. Thinking about data privacy as based on relationships of trust means several things. It means fostering disclosure and sharing of personal information by mitigating the risks inherent in disclosure. It means rebalancing the power between the data subject and the controller. It means understanding what the future expectations of data subjects might be based on what the representations to them are. And it means asking how the law can strengthen relationships of trust between the parties. Building this trust also means that PICs should make the necessary efforts in maintaining the accuracy and quality of personal data involved in their business. Inaccurate information will lead inaccurate results, no matter how sophisticated your systems are. And without trust in these systems, in these technologies, data subjects will not use them. And society as a whole won't be able to experience the full benefits and potential that they can otherwise get. Indeed, this is not just about avoiding the acts punishable under the Data Privacy Act, but acting according to your role as information fiduciaries in shaping the digital life of your data subjects. Note that even the word fiduciary comes from the Latin word for trust. Let's face it, by providing them with necessary services, essential services, you exercise power over them. In the same way that the law of fiduciaries provides that doctors, lawyers, and other experts who have power over us must act with our best interests in mind. Your duty to regain the public's trust entails the same. However, concerns are being raised with regard to how our trust can be manipulated to compromise our privacy. The ability of technology to inspire potentially misplaced trust is only growing. To provide an example, studies have identified that certain practices relying on cues of trust, such as likes and shares of people we know, are used to encourage other people to engage with specific types of content. While this may seem like an effective strategy to increase social connection, it can also raise deceptive practice concerns when it is used on things like native advertisements, especially when clicking those ads takes us to a third-party website with dubious or unknown data use practices. To address this, I would like to highlight the importance of implementing privacy by design. PICs, together with their developers, should implement the details of each requirement in the law so that the intended benefits of the use of your technology will translate into a structure that can obtain and maintain the public's trust. It is expected that businesses exert the same level of effort in the design and communication of their systems to their data subject. While design is crucial in ensuring proper compliance with the law, it is equally useful in communicating the necessary information to data subjects and making things as easy as possible for them to understand. After all, the manner in which something is communicated, its timing, its modality, etc., is as important as the matter that is being communicated. In fact, there are foundational principles of privacy by design businesses can adopt to better embed privacy into every standard, protocol, or process that affects data subjects. First, the privacy by design approach is characterized by proactive rather than reactive measures. This approach does not wait for privacy risks to happen, but seeks to prevent them from occurring in the first place. Needless to say, the ideal time for the controller to structure their systems according to an ethical framework is before they embark on a new structure and technology. This is also consistent with the timeline for a company to conduct its privacy impact assessment. By starting off on the right foot, companies avoid the burden of having to re-engineer their systems later on to make it compliant. Privacy by design also seeks to make privacy as the default in any given IT system or business practice. Building privacy into the system by default allows users to retain their privacy even if they are not doing anything to protect it actively. This is also consistent with the principle of embedding privacy into the design of systems and business practices. It takes into consideration the holistic, integrative, and creative way of putting privacy into technologies, operations, and information architectures present in any organization. Further, privacy by design seeks to accommodate all legitimate interests and objectives while avoiding making unnecessary trade-offs in the process. This means that privacy should be embedded into systems in a way that does not impair its full functionality, and if possible, ensuring that all requirements are optimized. Privacy by design should also extend throughout the entire life cycle of the data involved, from its collection all the way until its destruction. This approach ensures that end-to-end security of personal data with focus on protecting the confidentiality, integrity, and availability of personal information. This approach also seeks to assure its data subjects that their personal data is being processed according to the declared and specified purpose of the organization, putting a premium on visibility and transparency. Finally, adopting a privacy by design approach requires conscious action towards keeping the best interests of the individual in mind by demonstrating a high respect for user privacy. I'd like to point out that there is a specific provision in the Data Privacy Act that says that any doubt in the interpretation of the provisions of the law shall be liberally interpreted in a manner that's mindful of the rights and interests of the individual about whom personal information is being processed. This means that manipulating design or manipulating trust through misleading and deceptive design to induce disclosure of personal data and then working against the interests of the data subject is something that would necessitate the exercise of the NPC's authority. Finally, it's important, I think, that PICs, including the developers of their systems and technologies, understand their accountability when it comes to the implementation of these systems. One way to demonstrate this is to put in place appropriate policies, processes, and practices concerning the processing of personal data within an organization. PIC should also recognize that they have an obligation to make more thoughtful decisions and to assume greater responsibility for the consequences of the products, services, and technologies that they are developing. It is important that organizations consider and adhere to the best practices of their industry to better manage the personal information of their data subjects. It goes without saying that parties cannot use their data sharing agreements or outsourcing agreements to escape their obligations and responsibilities provided under the Data Privacy Act. In one specific case, we emphasize that the subcontracting of personal information by a personal information controller cannot include the responsibility to prevent any unauthorized processing or violation under the law. Once again, the obligation to prevent unauthorized processing, among other things, other potential violation, remains with the personal information controller that is processing the personal information. That's why the Commission found it beneficial to incentivize those who take the necessary steps to ensure that they are compliant with the DPA. One of the ways the Commission seeks to do so is the upcoming circular on administrative fines. Now, I know it may sound counterintuitive, but let me explain. The main guiding principle in the proposed range of fines is determining how we can balance data protection and the data subject's right to privacy, and at the same time, encourage further growth and innovation. What will be disincentivized is the misuse and abuse of data, especially by entities that take advantage of the people and their personal data during this pandemic. In formulating the circular, we avoided adopting a one-size-fits-all approach. Normally, when a fine system is implemented in the Philippines, you just have a single fine that applies regardless of the size of the organization. In this particular case, we recognized that the fine that is suitable for one company may not be what's suitable for another company. Following consultations with experts on economic analysis of law, we strive to make the cost of compliance cheaper than the cost of non-compliance. So hopefully with this particular measure, we encourage people to comply because doing so will be significantly cheaper in case they are found to be in violation of the Data Privacy Act. In doing so, we wanted to make sure that the level of fine is the right level to incentivize companies, taking into consideration their size, their income, the type of processing they do, and so on and so forth. Most importantly, the circular does not impose anything that is not already required by previous issuances. So This circular only provides a framework in which the fines can actually be imposed, how it's computed. From the point of view of data privacy and security, this can serve as another way to communicate and convince decision makers in your organization, assuming you are a DPO, to really invest in data privacy and protection. In fact, organizations should be able to put in place good internal governance processes as responsible custodians of customers' personal data. This involves gaining consensus from members of the organization's management on privacy as a business imperative. To do this, there has to be a coalition of supporters within the organization of accountability for information management and security, risk compliance, or legal decisions. Internal partners such as HR, legal, security, marketing, risk management, and IT should also be included in whatever conversations, as they too will have ownership of privacy activities and their buy-in will be necessary. Depending on the organization's industry and culture, executives, managers, and internal partners will each play a role in the development and implementation of the privacy strategy for an organization's privacy program. When organizations do this in the long run, both PICs and the data subject benefit from it. On the part of the NPC, we recognize the role of the sectors in creating an environment of trust, where the right to privacy and the use of personal data are well protected. At the same time, ensuring that businesses are able to continually innovate and maximize the benefits of these technologies. To do this, the NPC provides in-house trainings for data protection officers. We believe that with properly trained DPOs, businesses can have a proper direction in terms of their privacy compliance, and for them to gain a certain level of confidence in making sure that the things they're doing, especially those that involve our personal data, are aligned with the requirements of the law. We are also in the works of retooling this program in a manner that allows us to better reach DPOs who don't have the opportunity to attend sessions held in Manila. Hopefully, this will ensure that everyone has equal access to the knowledge and trainings provided by NPC. Additionally, the NPC provides a comprehensive set of guidelines through its official issuances, its decisions, resolutions, orders, advisory circulars, advisory opinions, all posted on our website. These serve as references for organizations as they embark on their data protection efforts, specifically in implementing their privacy management programs. These guidelines touch on things including cross-border trade. We have an advisory on the use of the ASEAN model contract clauses and ASEAN data management framework. With this continued advocacy for privacy awareness, I think organizations can only expect more data subjects to become aware of their privacy rights, which in turn can increase the number of complaints received by the NPC. As I mentioned earlier, from 2018 to 2021, our Complaints and Investigation Division received a total of 2,110 complaints relating to online lending applications. This trend should be able to encourage organizations to rethink how data privacy is being applied in their businesses. We can look at this particular figure as both a good thing and a bad thing. While indicative of potential privacy violations being committed by companies, I think it also illustrates the public's recognition of their rights provided under the Data Privacy Act, as well as the lack of observance of these rights. The sooner businesses realize this, I think the better things will be. They just have to be able to adjust to this increasing awareness of their consumers, of their privacy rights. I think at this point in time, businesses should realize that they now are part of an ecosystem where companies from the MSMEs to the multinationals all work together to create a society that respects and protects the individual's right to determine how their information will be used, protecting them from being another unwilling statistic that only benefits business interests. This increasing awareness isn't just confined to the Philippines. In a conversation with a consultative group to assist the poor, we learned of a study that they did in India where they presented different loan options for a low-income segment in Bangalore. In a lab testing environment, they offered a loan option that asked for data, but with little or no protection for privacy. The privacy policy stated that they may keep it for many years and they may share it to other entities. The people agreed with this because there was no other option. When they repeated the test with a different group, but this time provided other options, with one loan option having more privacy protections with their data subjects, the data subjects or the participants in that experiment being assured that their data will be deleted, it won't be shared. But this option was more expensive. The other loan option that was not protective was cheaper. About 60% of the customers chose the more expensive option. I think we have to consider that these are people from a low income area in India. And taking this into consideration, 60% still chose the more expensive option because it gave them more privacy protections. I think this only shows that people, regardless of their status in life, are starting to think about their privacy. Finally, I'd like to take this opportunity to encourage everyone that if and when you see something that is a cause for concern, whether it's specific to your sector or something else, please feel free to reach out to us. Your inputs are very significant in making sure that the NPC comes up with the most relevant and helpful issuances. We have to admit that the awareness of the Commission on these things are limited. We have our own set of perspectives, our own experiences, and we understand and recognize that we cannot see everything. Hence, we will need to continue collaborating and working with the private sector to ensure the relevance and timeliness of the policies that we come up with. In closing, I want to emphasize that this is a culture of privacy that we're trying to build. And it is something that all of us should build. It is a shared responsibility between government and the private sector. As professionals working in an organization that processes personal data, it is our responsibility to observe the obligations provided under the law. To name a few, we should collect information only for a legitimate purpose that have been made known to the data subject. We should only collect as much information as is needed to allow us to process that information, and so on and so forth. We should all know this by now. As with industrial and products development in the past, awareness of risk should not be seen as a barrier to innovation, but rather as something that can enable us to develop technologies in a more responsible manner. I trust that by working together, we can dispel the public's mistrust with the utilization of technology in financial services and obtain the buy-in of more Filipinos. Hopefully, we can say that through our collective efforts, we have contributed to the realization of our country's economic growth and ultimately the improvement of the lives of every Filipino. Once again, thank you and good afternoon to everyone.
Thank you, Deputy Commissioner Aguirre. And now we go to our next part, which is the question and answer portion. Let me introduce now the moderator for this part. He is a partner and executive director of Seed In, and of course, a trustee of the Fintech Philippines Association. May now introduce Mr. Edison Tsai to facilitate the open forum that we have with Deputy Commissioner Aguirre. Sir Edison, good afternoon.
Thank you, Chino, and good afternoon.
Hi, good afternoon.
To, Commissioner Aguirre, and to the audience. We have a lot of interesting questions that come in. So, Commissioner Aguirre, may I start with the first question? Is how
Sure.
important are data privacy and security in the data-intensive growing financial technology sector?
I think we have to go back to what data privacy rights are in the Philippines. We have to understand that data privacy is a fundamental human right So I think it's very important for the fintech sector to take this into consideration when they process personal data of their customers. I think in everything that we do, we have to observe the privacy principles of transparency, legitimate purpose, and proportionality. But at the end of the day, do this taking into consideration that what we're implementing is a fundamental human right that allows people to, I guess, be themselves. So I don't know how else to explain its importance except to emphasize what it is, which is a fundamental human right.
And the turnout of today's event also shows the paramount of importance for their respective organizations.
Yeah.
Commissioner, what are the benefits and notable impacts of the Data Privacy Act to the domestic fintech space?
I think as far as the benefits, it's important to look at data privacy and protection as something that allows a company to gain the trust of their customers, to gain the trust of their data subjects. Regardless of how good your service is, if people don't trust the industry, if people don't trust your company, they're not going to use it. Which leads us to what I mentioned earlier about what happens with certain bad actors in this specific sector. So by complying with data privacy, by being able to demonstrate that you are complying, then that benefits the entire industry by allowing the industry to regain the trust of their people, of their customers. So I would look at it in that way. It's not something that should be looked at as curtailing innovation. It's something that is a tool to gain trust. And gaining trust, as with any business, the trust of your customers is very important. That's why we have things like goodwill. So data privacy should be looked at as that. It's an enabler of trust, which is what will allow a particular sector to grow.
Very important, Commissioner, especially that you mentioned trust. And in order to establish that, how are we to explain or best communicate the manageable risk of data sharing versus having unregulated fintech?
I think it starts by first under the fintech companies understanding exactly what they're doing. Because the better you understand what you're doing and why you're doing certain things, why you're collecting certain things, the better you will be in terms of communicating that to your data subjects. I think with everything that's happened in this specific space, there's a lot of mistrust already. So communicating things in a manner that your audience will understand, I think that's important. The audience of this particular companies are not exactly lawyers. It should not necessitate the services of a lawyer to be able to explain to your data subjects exactly what is going to happen and why you're doing certain things. So being able to explain exactly what is happening to them in a way that they will understand is important. But having said that, on your own, I think it necessitates a reevaluation of certain processes that are being done. Why do you do certain things? Is it necessary? If it's not necessary, then change it. Because that is the fair and just thing to do. That is what the law requires. As I mentioned in my talk earlier, we can't pass the burden entirely on the data subjects. The company also has to have an obligation to ensure that they're doing what they're doing and they're not doing anything more than what is necessary to provide the service that their data subjects want. So I think those two things are important, but that all begins again on a clear understanding of why you're doing what you're doing.
And
which
that brings us
which
to our next
necessitates the
question.
conduct of
How
a privacy
critical?
impact assessment. Sorry,
Yes, yes, Commissioner, definitely. And how critical it is for financial institutions and fintechs to build and protect trust of their customers while promoting a stable and lasting partnership in how and who handles their finance.
I think it's not specific to the fintech institutions or the fintech industry, but I think looking at businesses in general, it's important for businesses to gain and maintain the trust of their customers. A quick buck now, but you lose your customers and you lose the trust of an entire people doesn't make sense in the long term. So if we look at privacy as an enabler of trust, then now again, not just for fintechs, but for business in general, then I hope we place that much value on privacy. If we're spending so much, for example, on advertisements to get customers, I hope we put the same value to not just spending on privacy, but actually prioritizing privacy because it allows us to keep customers because they trust us. They know that they can continue business, engaging in business with us. They know that it's safe to disclose their personal information with you.
And that has a long-lasting implication for financial technology providers. And definitely, what do you say, Commissioner, are the implications of data privacy for financial technology companies and uh, in, uh, in the industry in general, here and across Asia?
It's hard to say the implications of it in Asia in general, but I think we are seeing that a lot of other countries in Southeast Asia are in the process or have passed their own privacy regulation. And if we look at the idea of financial technologies as not just confined to a specific geographical area, but you are now able to transmit, engage in transactions across borders, especially with a lot of Filipinos that are working outside the country. I think that makes it even more important for data privacy because you will now have to contend not just with the laws of the Philippines, but even the laws of that particular place where there is another Filipino that seeks to utilize a particular fintech solution to transact, to transmit money back to the Philippines, and so on and so forth. So I think we are only beginning to see how important it will be as financial. I don't really see financial technology stopping. I think it will just continue to grow. And as it grows, then the importance of privacy will grow with it because people will now begin to see that, okay, there are certain risk factors here. How do we address that, taking into consideration data privacy and protection? So I think it will go hand in hand. And that's why this relationship between the private sector and the government is very important because we can't do it by ourselves. There is um, mutual benefit in working together, ensuring that we come up with proper issuances, proper approaches, taking into consideration the realities of your specific sector.
Thank you, Commissioner. And may I also cite some questions from the audience as well? So we have from Miss Mary. She's an affiliate to the DOST National Research Council of the Philippines. And as a collegiate body, they are maintaining both personal and professional data of more than 5,000 members. And they regularly collect these data from their membership applicants. So this is a series of questions, but uh, uh, Commissioner, feel free to answer them in bulk. So the first question is, what framework or mechanism should they adopt to manage and protect the data of their members? Where and how do they start? And do they start by having a DPO or data privacy officer?
Having a data protection officer is important because that person should be knowledgeable in terms of guiding the organization through its journey of compliance. We don't expect the DPO to do everything, but at least that person can help guide the organization. Some of the things that you have to look at will be, what are you collecting specifically from your members? Do you need everything that you're collecting? How are you storing all of these information? What do you do with them? I think these are important questions that you should be able to answer as you go through your privacy impact assessment, which your data protection officer should be able to guide you through. I don't exactly know the details, but I think the important thing to consider would be, what are you collecting? Why are you collecting it? Do you need all the data that you're collecting? How do you store it? What do you do with it? Then take it from there.
Thank you, Commissioner. And given
Hi,
that, yes,
Chair
Ms. Amor.
Edison. Hello, hi. If you'd be so
Hello.
kind. We recently, I'd like to just quickly address the question of Ms. Charlotte. I'll post my contact information. We recently entered into a partnership to help capacitate the DOST PSERD specifically, who's the standard bearer for research of the DOST. And maybe what we can do, Commissioner, with your permission, is I'd like to bring the commission together with the DOST, especially because for this year, the DOST is looking into more nascent technologies related to Web 3.0. So that would be this entire universe. No? And with your permission, also, Ms. Charlotte, no? Chino, maybe you can post my email information and we can connect them. Thank you.
Sure, Amor. Thank you.
Thank you, Amor. And I think a lot of the basic question revolves around, if they're going to start having a data privacy officer, what are the typical requirements or qualifications for them to start looking?
To start getting a data protection officer?
Yes.
Well, one, I think it's important to stress that you don't actually need to have a certified DPO. The important thing in getting a data protection officer is to ensure that that person is knowledgeable, has on-the-ground experience and not just theoretical. So getting an understanding of what this person has done, their experiences, what trainings they've attended are all very important things. Again, it's important to stress that your data protection officer is not the one that will get in trouble when something happens with the DPA. It's also not the one that will be solely responsible for getting the company to the point of compliance. Your data protection officer, I look at it more as a project management role, to be able to bring all the different groups within an organization together, get them to understand what they need to do to get the company to the point of compliance. So having someone that's knowledgeable is one thing. Being able to work with the different organizations or departments within an organization is equally important. So all of those things are things that you can consider when you're choosing which candidate for a data protection officer you're getting.
Hi, Commissioner Edison. Maybe one of the things that we can also collaborate with Commissioner Dindo would be to undertake upskilling, reskilling, certification courses for DPOs or those who are exploring careers in this space, because capacitating DPOs is one of our thrusts. Education is one of our thrusts. So maraming salamat. Thank you.
One last question on the DPO side, because we have attendees who have affiliated companies. Can they have a common compliance officer for affiliate companies? So shared resources between the companies, or does the commission require that each company has to have its own DPO?
Okay, you can have a common DPO. We're in the process of amending our circular on this, but the idea is you can have a common DPO for all of your companies. It really is up to the company to come up with what, in its opinion, is the most effective and efficient way for it to manage its privacy compliance. So if the decision is to have a common DPO, that is fine. You just have to register that with the National Privacy Commission. We will require, though, that each of the different organizations have a unique email, even for this single DPO, just so it will be easy if we are dealing with company X. We know that when we email this person, it's in relation to company X. So his email is specific to that. So his role as the common DPO for that affiliate or that subsidiary. The same goes with a compliance officer, although ideally, it wouldn't really make sense to have a common compliance officer. It would make more sense to have a common DPO than have a compliance officer for each of your subsidiaries or affiliates. That way, there's a point person on the ground, because let's face it, isang tao lang yan, hindi naman niya mababantayan lahat na nangyayari, especially if you're talking about a huge conglomerate.
Thank you for the question that the attendees today have.
Edison, I can't hear you.
Commissioner, is it okay?
Yeah, I
me
can
now?
hear you now.
All right, thank you. So I think that's actually the question that a lot of the attendees today have with regards to where to start and the qualifications, as well as whether they can have a common compliance or DPO. And moving forward to the question on the data, one question from the attendees from the audience is, what can you say about institutions and organizations that make gender, age, cell phone number as required information in the registration and evaluation of the webinars? And if these information are not provided, either they cannot continue with the registration or they will not receive their certificate of participation. So this is more in line in the tune of attending webinars.
Okay,
And
so
data privacy.
I hope it doesn't apply to this specific webinar. I hope hindi kayo yung pinapatamaan niya. But I think the important thing is for those that are organizing webinars to understand why they're collecting all of these things. Why do you need age? Why do you need gender, for example? Cell phone number, maybe I can understand. But those two things, maybe it's not necessary if we're just documenting who participated. What can I say about them? I think that there has to be a clear relationship between the purpose for the collection and what they're collecting. If there is no connection, then that will be considered as unproportional and therefore potentially violative of the DPA. But we'll still have to look at it case to case. We're not making a general judgment. Oy, sumobra ka ng collection. May one category of personal information kang sobra na kinolect, therefore makukulong ka. No, we're not doing that. We're still looking at things case to case and giving these people an opportunity to correct it if it's not to the level that will require prosecution. If because there's a statement, oh, it will not proceed. I want to again emphasize that consent does not justify overcollection. So just because they consent, because they don't really have a choice and they really want to attend your webinar, doesn't mean it's okay. There's still an obligation on the part of organizers or companies to ensure that they're doing things in a proportionate manner. So I hope everyone keeps that in mind.
And in terms of Data Privacy Act jurisdiction, it affects both locals and foreigners, right? Is there a difference with the way it applies on locals or foreigners?
As long as the processing occurs in the Philippines, or even if the processing is outside the Philippines, but there is a connection to the Philippines that can be traced, then it applies. So even if, for example, there's a social media platform that has their processing activities outside the country, but it's targeted to people in the Philippines, then the Data Privacy Act still applies.
I thank you, Commissioner. I also have a additional comment from Ms. Charlotte. DBM requires sex disaggregated data as part of the gender equality advocacy program of the government.
Okay, Now, if that is the reason, then I think it's just good to include information on that as to why you're collecting certain pieces of information, because not everyone will be aware of that. So they may have certain questions. So it's still good to provide information on that through a privacy notice when you're doing all of these collection activities.
Commissioner, what is your insight with the SIM card registration app, as some may consider it a threat with privacy and in line with continuous incident of financial scams, mostly was through mobile numbers?
I think it's hard to make a conclusion that it's automatically a threat to privacy. Does it pose a threat? Yes. If it's not implemented properly, then yes. We also have to consider that with the SIM card registration act, it involves not just SIM cards, it also involves the registration of social media accounts. So I think what's important here is monitoring how it is being applied, ensuring that the proper protections are included in the implementing rules and regulation. And in order to do that, it's not just government, but citizens, society groups also have to play a role in monitoring this. At this particular point in time, the bill is already before the president for signing. So it's either he vetoes it or he signs it. But that being said, if there is if he does sign it, then we have to be vigilant when it comes to how the implementing rules and regulations are being crafted, to ensure that the risks to privacy that may be there are at least mitigated or prevented altogether.
The questions keep flooding in, but I think we have only room for two more. If that's okay with you, Commissioner.
Sure.
Thank you. So, what the second to the last question, I'll combine two questions in one, but in relation to lending apps, because of course that's a lot of people, our livelihoods are being affected as well. So if the person or the borrower did not pay on the specific days that's on the repayment schedule, what is the extent of the lending app in terms of how they hold the data on the borrowers? So what can they do with it, and what can they not do with it? What is the limit in terms of how they can use the data?
I think first we have to. Edison, did you read that from the Q&A? Sorry, I'm trying to look for that specific question.
It's in the well, it's in Filipino.
Okay. Okay.
In English ko lang.
And then no, it's okay. I think what's important first to clarify is the NPC's jurisdiction when it comes to lending apps. The NPC has jurisdiction over the processing of personal information. Things related to unfair collection practices are with the Securities and Exchange Commission. So yung mga namamahiya and all of those things, sa SEC po yun. Ang NPC, what we are regulating are over collection of information. For example, if by installing this particular app, automatically kinolect niya lahat ng calendar mo, messages mo, contact list mo, at ginamit niya yun for collection purposes, that's a different thing. That's what we cover, what we have jurisdiction over. Because under the issuances of the NPC and the SEC, an online lending app is only supposed to communicate with the people that the data subject provides in their application. If they contact someone else, then that's over collection and that's a violation of the DPA. Pero yung manner of collection, manner of communicating to the data subjects, sa SEC po yun. Unfair debt collection practices po yun. Hindi po yun sa NPC. So yun lang po yung gusto ko linawin. But it seems like most of the question really pertains more to unfair debt collection practices. So sa SEC po yun. Yung sa amin, hindi sila dapat mag-overcollect, hindi nila dapat lampasan yung dinisclose nila sa data subject dun sa kontrata, sa terms and conditions, sa privacy notice. So dun po yung sa NPC. Kung napansin nyo na 5 pangalan na yung binigay nyo pero yung buong contact list nyo yung pinadala nila ng message na may utang kayo, yun po, sa amin po yun. Pwede kayo mag-complain sa amin.
Thank you, Commissioner, for clarifying that. And last question for today. What should the leaders today and tomorrow do to improve the data privacy of Filipinos?
Parang pa Miss Universe po yung question. No, no, I think what's important is that we understand exactly what our roles are at this point in time. Each of us, not just leaders, each of us have specific roles that we play in our organization. Understanding how our roles impact the privacy of our customers, of our fellow employees, goes a long way in ensuring that that organization builds a culture of privacy. And if each organization has that mindset, has a mindset that we're only processing information within this framework of protecting the data subject rights of Filipinos, looking at things not beyond a mere checklist, oh, meron ako 1, 2, 3, 4. But with this understanding in mind, ensuring that they're doing things fairly and justly, then I think we will get to this point of improving the privacy of Filipinos, allowing us to be able to trust the technologies that we're dealing with, be able to trust that when we disclose information to certain offices, it will not be misused, which will be beneficial for all of us. If people trust the business, then the business will grow, the industry will grow. I think it's important to understand that those making a quick buck, in the short term, panalo ka, but in the long term, it affects your entire industry, it affects your business. So I hope we look at things from that perspective. Then I think that hopefully that will result in what this person is saying, improve the privacy of all of us, not just Filipinos, but everyone in the Philippines.
Thank you so much, Commissioner. Those are some wonderful insights, and for the audience as well. I'm sure we have learned a lot today. So thank you so much, and back to you, Amor, Chino.
All right, thank you so much. Thank you so much, Edison, for moderating this wonderful Q&A. Thank you so much, Attorney Aguirre, for the wonderful insights. At this point, may I invite all the our guests as well, and our speaker to turn on your camera. We'll just have a photo opportunity. All right, so I'll just count down. All right, 1, 2, 3. All right, one more. All right, 1, 2, 3. All right, maraming salamat po. And again, thank you everyone who has attended this webinar. Wow, there's still 500 attendees. We still have 500 attendees here in the room. Again, we would like to thank Deputy Commissioner Attorney Aguirre for the wonderful insights that you have shared. Perhaps we can plan out another or a second leg to this wonderful webinar. I think a lot of the insights and a lot of the questions are still rolling in, so perhaps we can plan that out with of course the Fintech Philippines Association. So again, maraming salamat po to everyone. Thank you so much, Sir Edison. Thank you so much, Ms. Amor Maclang, and to the rest of the Fintech Philippines Association. Thank you so much for hosting this wonderful event. Ms. Amor?
Tino, I just wanted to, in behalf of the Board of Trustees of the Fintech Philippines Association, specifically our chair, Dr. Tito Ortiz, we'd like to thank Commissioner Dino for all his support, and also wanted to just share quickly that we actually had 1,700 registrants. And I was so mindful. We had to double check. We just collected the name, the email, and the mobile, just for purposes of being able to send you the link. But we had 1,700, and many of whom, including members of our board, were turned away because we've reached maximum capacity. So thank you so much, Commissioner, and we look forward to this ongoing co-advocacy with you and the NPC.
Thank you, Amor, and thank you again, everyone, for having me, having the National Privacy Commission, and for giving us an opportunity to share more about what we're planning to do, our thoughts on these things. And so there, thank you again.
Thank you.
Thank you.
Thank you,
Maraming
everyone.
salamat.
Mabuhay po ang NPC. Bye.
Thank you.
Bye.
Thank you, everyone.